Welcome to another episode. I am your host, Emerson Jarrad. Let's get to the meat of the subject, what we're talking about today. We're talking about understanding real estate contracts. And my special guest today is Anthony Russo. Well,
So it's very important to get an attorney who reviews the contract and tailors it to your needs as a buyer or seller. Although we do use a form, there's a lot of little nuances in it. And depending if you're a buyer or seller, that contract needs to be modified for your needs. And that's an important detail.
we're filming this, we're both in New York. So, downstate New York, basically, typically, it's usually who actually creates the contract, who starts the
The,
contract, and then.
yeah, downstate New York, the seller's attorney drafts a contract, sends it to the buyer's attorney for review. Upstate, the trend is I think the agents or brokers draft contracts, but downstate it's the attorney for the seller.
Okay, so walk us through the contract. What's in a typical contract?
Okay. So typically a contract from a seller has the terms of the deal. That's why it's very important to get a deal sheet from a realtor, the agents, a transaction summary that contains all of those facts so that we can turn a contract around quickly, either prepare it quickly or review it quickly from a buyer's standpoint, especially in a competitive market. The contract will have the parties' names and addresses. It'll have a specific description of the property, whether it be an address, a legal description, a block and a lot, depending on the particular property. If it's a co-op, it would have the number of shares, the name of the co-op, the maintenance amount, the tax amount, the management company. If it's a condo, there's a percentage of common ownership, of an ownership interest, the specific name of the co-op or the condo. In any contract, it will have the purchase price, the amount they're putting down on contract, which is critical, and then the amount they're putting in the deal in total. And then one of the most important factors is the amount of the mortgage that they are seeking, especially if the contract is going to be contingent on them the buyer obtaining a mortgage. It's called a mortgage contingency clause, and that amount needs to be specific. And that's another story I could explain when you're ready.
All right, and I'm pretty sure I'm getting a message right here in my head. Is the contract similar? Is it a slightly similar basis if it's a cash deal? Is there any difference?
Very similar. When it's a cash deal, there's really no contingencies. So from a buyer's perspective, they're going to be locked into that contract when it's a cash deal. When it's a mortgage contingent contract, a finance contract, there's going to be language that allows the buyer to get a mortgage or apply to secure a mortgage, and then reasons why the buyer is not obligated to go forward and can get back their deposit if they do not get a mortgage for certain enumerated reasons, certain stated reasons, not just because they chose not to do it anymore, but there are certain legal obstacles or financial obstacles they did not meet.
All right. So walk us through basically the seller prepared the contract. They sent it over to the buyer's side, the buyer's attorney. Now what?
So this is a key fact in the process and something I pride myself on. Getting a contract from a seller's attorney requires that I actually print out the contract. I look it over line by line, and I usually physically edit the contract to add language, or it's just even a few words here and there that will help my buyers or protect my buyers more than it's already stated in the contract. There's a certain way of practice, so I cannot get the buyer rights generally that they don't have, but I will make sure those rights are protected and stronger in many ways. So if someone has a time limit on them responding or me responding for them, I'll expand those time limits. If there is a default provision that says if they fail to comply, they're in default, I'll say it has to be a willful or continued type of default that goes on longer than us just missing something. So those are little nuances that the buyer's attorney will review a contract and kind of edit the contract to get those in there, and has to get the agreement of the seller's attorney for that to be permitted.
Okay, so now you review the contract. What's the next step after that?
I send it back to the seller's attorney. If he or she approves my changes, which I'm generally successful in getting, I will then speak to my buyer and have a Zoom call or face-to-face meeting to go over that contract. I'll send it to them by email usually, and they can review it with me or meet me in person and go over those key terms so that they know exactly what they're signing on to. The terms of the purchase price, the details of their mortgage obligation, and more importantly, the timeline in the contract and what happens if things get delayed or go wrong, how the contract plays out to protect their rights.
Okay, so now the buyer has signed the contract. It's sent over basically to the seller side, and they also have the down payment. Basically, there's some escrow basically that's
Yes, it's
collected.
usually a down payment to keep the deal alive, to make sure they have some skin in the game, as people say. Yes.
All right, so that's sent over to the other side, and then now the seller's attorney basically is meeting with their client, and they're meeting like you probably either face to face or they're doing a Zoom or
Yes.
something of that nature. Now, when that seller signs, what happens next?
The seller's attorney will send it back to the buyer's attorney. And then once I have that contract in hand, I would send it to the realtor, the client, and their banker, so that everyone could start doing their jobs. Because once the seller signs, then we're actually in contract. The deposit gets deposited in a bank account for the seller's attorney. And now that buyer has to proceed to get their mortgage, to have title searches on the property done to make sure they can get title insurance. And the realtors need to know that so they can mark it as, fully in contract, and then continue to assist the clients throughout the way so that they can get their mortgage, clear title, and then get to closing.
Okay, great. Now, typically, what are the most common things that you see that would hang up a contract getting signed by all parties, and what's
Well,
the solution?
you'd be surprised on the lag of time on things and the absence of information. So when I speak about topics like this, I tell everyone to get prepared, be prepared, have your documents ready if you're a seller, have your attorney and banker lined up if you're a buyer, have your pre-approval, obviously, have the terms of the contract, the deal, the down payment. A lot of times I'll get a deal sheet that's missing how much is their mortgage, what's the target closing date, how much are they putting down now on the contract? And those just have us go back and forth between the attorneys when we could be moving towards contract, especially when it's a competitive market and we need to move things along.
We have a situation where the seller is they're selling this particular property and they're also buying. Now, could you put something in the contract regarding that?
We can, but it's rarely accepted. And that's why it falls upon sometimes the agents, the brokers, when they negotiate the deal. If they can get that agreement, then we can try to carry that out into the contract. And we would. Most attorneys would be resistant to allow that. But if that's how the deal is structured, we have to carry on our client's wishes. But a lot of times people know that's coming, don't want to bring it up. We get the contract and they'll say, oh, just tell the attorney you're not going to do it unless you sell your house. And when I put that in, an attorney is going to be shocked. And remember, it's another layer. That attorney's trying to protect his or her client, and they're going to, advocate against that type of, situation. So if it's agreed upon, we can do it, but it is rare.
All right. My next question is basically how important is it for when it comes to negotiating? Well, the negotiating basically is usually done by the realtors. When it comes to the contract, how important is it basically that it's a real estate attorney who is familiar with the language of the contracts and they have a good reputation speaking back and forth to the other attorney on the other side?
Yeah, it's probably one of the most important things. Whoever you use should be a real estate attorney. And I say that because then he or she knows what to ask for, and then what to give. And more importantly, when you're negotiating with the other attorney, even over contract terms or whatever might come up, you're able to deal with that. You can disagree and still have two different parties. I represent one, he represents the other, but we can have a common discussion about what we need to get us to the finish line. When we deal with someone who does not do real estate regularly, because some people think it's a simple side business for them when they're not in court or things like that, and you can't get them on the phone, they want to fight, they threaten litigation over anything that comes up, and that is counterproductive. That does not help us advance where we're going. So two people speaking the same language definitely makes a smoother conversation. That's the best way to explain it, and it's the key feature in this practice.
Not only is it counterproductive, it takes up a lot of time and energy. Had the conversation been had, if it was somebody who was well versed in
Sure.
that particular structure, they would know exactly what's coming
Sure.
up, what to expect, and then they wouldn't be more adversarial to the other party. They pretty much know that they're doing their job and they're protecting their client just like they are protecting their client.
Yes.
And it is two different worlds basically if you're representing clients basically in the court versus basically someone who's doing a transaction
Yeah.
going back and forth.
Very true.
My other question regarding contracts, I would have to say, is the top one I'm hearing right now are pretty much people were selling homes and sometimes they have tenants in the property, and or basically they are buying another property and they need time to move out of the property to get into the next property. They assume that they're going to get out a specific time. Can they put that into a contract?
Yes. So it is very standard in contracts to have a provision that allows the seller approximately 5 days to hold over, stay over after closing if needed. It's been longstanding the rule or understanding that we do that. I have it in all my contracts. Some people don't like it, and I understand why they don't like it. It's not a good arrangement, but it is the way the practice is. And it usually comes from necessity, because a lot of times if a buyer has a bank or whatever reason needs to close right away, the seller may not be ready or may not be able to get their mover or for whatever reason to get out as of closing. So as a right, it gives the seller the right ability to close and stay over for about 5 days. Obviously, money gets held in escrow to make sure they get out and leave the property in the proper condition. And they pay the buyer's mortgage interest for the days they hold over. If they stay past that, it becomes a penalty. So it motivates the seller to get out. That is typical, although a lot of people don't like it, as I said, and some won't put it in or strike it. But I do advocate for that for all of my sellers. Tenants are another story. Most people don't want to buy property with tenants, especially since COVID. It's very difficult to evict tenants, and rightly so. And whoever buys the property doesn't really want to inherit that problem. So either they're going to take it with that tenant, and if it's a two-family or a multiple family dwelling, or if it really has a tenant, they're going to want that tenant to be evicted before they actually close on the deal.
Now, with tenant issues, I always recommend basically an attorney that specializes in that particular thing. So you have your real estate attorney for one thing, and then you have your eviction, tenant, landlord attorney for that. Now, if another scenario that we have, which unfortunately does happen a lot, well, there's two actually. There's divorce, and then there's also, unfortunately, there's death, basically. So I always tell my clients for those particular matters, you have the attorneys that handle that part, especially when it comes to probate and stuff like that. They're handling that part, and then your real estate attorney handling the real estate part.
Correct. Definitely.
Is there anything else you want to add, basically, to our conversation to the viewers? So
No.
I know a lot of this might be, wow, it's too much information at the same time. And what piece of advice would you give people?
It is a lot of information, but we touched upon at least two of the key factors. One, be prepared, have all the details that are needed. That's my job to get them. So I definitely advocate or push to get that information so that we can do a contract or negotiate a contract properly. Use experts, use people who are experienced in this field, not just an attorney, not just a doctor. If you're going for heart surgery, you don't go to just a doctor, you go to a heart doctor. And the same thing with real estate. It's not rocket science, but someone who specializes in that field is really what you need. And really, being careful, planning and protecting and knowing what's ahead is the best, way to do it. So you know what to expect. God forbid something takes more time or goes wrong. You know how the contract reads and will, direct you accordingly.
All right. One of the things that you do that a lot of attorneys don't do is basically when you give out your card, you also give out your cell phone number, which
Yes.
I like. I don't know if your family likes that because basically people call more hours.
They get it. They like it. They don't mind.
It's very crucial that basically you have access to your attorney if you have questions and stuff like that. And you do respond to people over the weekend as well. Obviously, I tell my clients, look, he has a family. You can call him, you can text him, but please be mindful he has a family. He's spending time with his family as well. So the other thing I would say is basically, since we're talking about communication, if somebody's interested in speaking to you, just they have a scenario and stuff like that, how can they reach you?
Sure. You can reach me on my office number, 516-746-7371. My cell phone is 516-312-7249. And my email is awrusso@awrussolaw.com. And as Evan said, I am more than available. I certainly have a business, I have a family, but I respond. You will hear back from me very quickly. And, as I said, even if I can help or guide in any way, I'd be glad to do it.
All right. Well, I'm going to give you the last word basically to our audience. I'm just going to give my plug before I give you the last word. Anything real estate, when it comes to buying, selling, or investing in real estate, feel free to reach out to us. If you found value out of this, please let us know. If you have questions about stuff basically so we can talk about in our next episode, let us know. My contact information is 917-975-5985. Truly, you can find us on Instagram, YouTube, Facebook, LinkedIn, pretty much every one of these social media platforms. Our website is also mynyhomesales.com. And Anthony, give us some words of encouragement to people who are thinking about buying and selling in 2024.
Anything you do in this world is risk. Buying or selling has risk involved. Going to a good attorney will minimize that risk, obviously, so you know what risk you're getting into. And that's the best advice I can give someone. Know what you're getting into and make sure you have an attorney who's going to protect you as best as they can.